At Burris and Ridgway, we are a personal injury and workers' compensation law firm handling cases across the state of South Carolina. Out of our offices located in Lexington, Columbia, and Orangeburg. We also handle domestic matters like adoptions and divorces and child custody. And we do a fair amount of criminal defense matters, including DUI defense. I want to touch for just a moment on something that we hear quite often, and that is something that I think it's a misconception that clients have about what we call premises liability. Premises liability cases are cases where a client has been injured on the property of another, and simply because there has been an injury, the client comes in thinking, well, there must be a recovery. In South Carolina, premises liability cases come to us more often than not as cases that involve a trip and fall or a slip and fall. Generally speaking, that's what they are. In South Carolina, to prevail on liability in let's use a trip and fall case, for instance. To prevail on liability in a trip and fall case, we have to be able to establish one of two things. The first would be that the shopkeeper or the storekeeper, or let's say you're in a major retailer, that the major retailer was aware of a hazard that existed and failed to remedy that hazard. In other words, that shopkeeper had actual notice that there was something on the floor or there was something that could trip you, and they did nothing to stop it. That'd be the first thing we'd have to prove. The second thing, if we couldn't prove that, the second way you could get to liability against a shopkeeper or a storekeeper would be to prove that the storekeeper or the shopkeeper actually created the hazardous condition that caused the injury. A very famous case in South Carolina dealt with some grapes on a floor in a grocery store where somebody fell. Let's use that, for instance, under the two-pronged test I just gave. The first thing we'd have to be able to establish or potentially establish would be that the grocery store knew that the grape was on the floor before the lady fell and failed to take action to remove the grapes. If we couldn't prove that, the second thing that we might be able to prove to establish the liability would be that the grape was put on the floor by the shopkeeper, the storekeeper, one of their employees. Without one of those two things, you cannot prevail in a liability case for premises liability in South Carolina. At Burris and Ridgway, we evaluate a lot of premises liability cases. We have some real success with premises liability cases. We also have a fair amount of cases that come in that we just aren't able to help somebody on because the facts just aren't what they need to be. If you would like, we would be more than happy to speak with you about your premises liability case. Be more than happy to give you a free consultation at your convenience.